Over the last few years, alternative data, or alt data, has been changing the way investment funds make decisions. Today, investments valued in the millions of dollars or even billions can be based on information such as internet scrapings or satellite imagery. But with so much alt data in finance, how has the SEC responded? Our guest today is Igor Rozenblit, who long served as the head of the private funds unit at the SEC, and who now is a partner at the regulatory consulting firm Iron Road Partners. Igor, welcome to Talks on Law.
Thanks, Joe.
Today we're talking about alt data. Maybe let's put on the table a quick definition. What are we talking about when we say alt data?
There is no alternative data definition from the government, and I don't think that's particularly relevant. I think to the SEC, data is just data. I think the SEC feels comfortable that traditional data sources such as 10Qs and 10Ks pose little risk in MNPI. And when at least the exam division thinks about where they're going to look, they look at data as a whole, and inevitably it's alternative data.
Why don't we get into a quick conversation on when alt data is illegal? I guess at the top you mentioned there's some privacy concerns, but let's focus on the securities law aspect. When and how does alternative data, how is it used illegally?
There are a couple of threshold questions before you can determine whether or not the data that you're using is being used in an illegal way. The first question is the alternative data that you're using material non-public information? And that, as I think many of your listeners know, is a very hazy topic, and there are no hard and fast rules around that topic, but there are a couple of rules of thumb. So any data, I think, that's obtained in a public way is probably safer than data that is not obtained in a public way. So for instance, any satellite data where the satellite is kind of orbiting the Earth and taking pictures that anyone could obtain is probably not MNPI, whereas any data that you get from credit card transactions or from people's credit card transactions, which is not readily accessible by anyone, does run the risk of being MNPI. And there are various data sets and various approaches to getting data that could fall into one or the other category. For example, app data might be closer to MNPI, whereas data coming off of location services might be a little bit farther away from MNPI. And what we advise folks to do is unless they are fairly comfortable defending the notion that the data set they're using is not MNPI, they should treat it as if it was MNPI and take precautionary measures from there.
Igor, there's been somewhat of a famous case involving alt data. This was the App Annie case. Could you walk us through what happened there and how alt data was found to be violating securities law?
Sure. So App Annie is a company out in San Francisco that develops software that sits on most apps that you use on your phone. And as you use the apps, it collects data about how you use the apps, what apps you interact with, and how often you interact with those apps. It packages that data and offers that data for sale to various parties, including parties who advertise to you and including hedge funds, which could use that data to trade. In this particular case, App Annie represented to their hedge fund clients that they were providing panel data. So this wasn't the actual data about app usage for every single app for every single person, but in fact, it was just a panel of different apps put together that hedge funds could use for some directional guidance about how apps were being used in general. So it wasn't specific information. The problem was that it wasn't anonymized and it was specific information, and it was excellent data that hedge funds could use to trade. And it's that misstatement that App Annie made to its clients that ultimately caused them to be charged under Section 10B, which is the section usually used for insider trading laws. And to date, that is the only kind of securities law alternative data case out there. But on the heels of that, a lot of questions have been asked. And one of the questions is, if you sell de-anonymized data from an app data provider, that's really good data. And it's also could be obvious that it is not the data that you contracted to buy from this particular vendor.
Yeah, that's an interesting point that you raised, because in the App Annie case, it was App Annie, the data aggregator, that was
Vendor.
in the sites of the SEC, not the actual funds. Is there a reason for that?
I think that the reason for that is that App Annie made some affirmative misstatements. They basically lied about what data they were selling to clients. And so if you're a government entity and you're looking for one particular perpetrator, you're likely to hang your hat on the perpetrator that actually affirmatively misstated something, as opposed to one of their clients who could have been lied to, which is actually what the order said, but who might also have looked at the data and said, you know what, this is de-anonymized data. This is not what I contracted for. I might not be able to use this for securities trading because it could be MNPI, and then use that data anyway. That's a much harder case than to go after the actual perpetrator, which is what happened.
So you mentioned insider trading. Are there other securities laws that are implicated here when it comes to using alt data?
Another part of alt data that we actually haven't touched on yet is internal data science teams and internal data generation. And I think kind of most of that boils down to web scraping. And one could say that, web scraping is not MNPI because by definition, if something's on the web, it's publicly available. But there are sections of web scraping that I think is worth some consideration. The two particular ones are CAPTCHAs, which are designed to make sure that whoever's interacting with a website isn't a robot. And of course, you are a robot if you're web scraping. There are two kinds of CAPTCHAs, one where you just have to solve a CAPTCHA, one where you have to click, I am not a robot. And I think for that second kind, it's worth considering whether or not it could be considered deceptive to click that box. The other kind of web scraping that should kind of fall under the purview of the compliance programs is any data that is obtained from a website where you have to log in. So if you have to create an account, enter in your personal information, log in, agree to a terms of service, I think it's worth analyzing at least the terms of service to see whether or not you can scrape past the login. I will tell you that industry practice right now is to scrape past CAPTCHAs, but not to scrape past logins. But everyone really has a different approach to solving that problem.
So the SEC wants to make sure that not only are companies not trading on material non-public information, but that they're not running amok, violating every website's terms of service in the process?
I don't think so. I think in the U.S., it's perfectly legal to trade on material non-public information as long as you don't have a duty to keep that information private, or as long as you didn't obtain that information using some form of deception. Logging into a website or clicking I am not a robot when you are a robot could be considered deception. So to the extent that you're getting material non-public information from websites and you have stipulated that you are not a robot, or you have agreed to terms of service that say you cannot use the information obtained for various activities, that could be considered deception. And stepping back from MNPI, any information obtained using deception could violate another securities law that prevents deceptive practices.
Which one is that one, Igor?
Well, the securities laws are pretty flexible in that. And so, again, Section 10B, which is the section that App Annie was charged under is a section that prohibits misstatements of material fact or omissions of material fact in securities transactions. Section 17A of the Securities Act prohibits the same. And so it'll just take a creative investigator to explain to a judge how you're agreeing to a click wrap agreement that says you are not a robot when in fact you were, could be viewed as a misstatement of material fact when you're engaged in securities transactions. So I don't think that's actually that far afield for what could happen. It just, I think, takes some desire on the part of someone to go ahead and make that case. There's another section in the securities laws, section 204A, which relates to each investment manager being required to develop sufficient policies and procedures to avoid mishandling of material non-public information. And it's that regulation, not the insider trading laws, that I think are most at issue for fund managers. It's really hard to establish insider trading. You need, for instance, intent in order to be insider trading. Whereas for this particular section, you just need to have insufficient policies and procedures to handle data. And I think that most managers who use alternative data are at some risk of violating that particular provision. What we've seen on exams at Iron Road is that is the provision that is cited by the exam staff when issues in alternative data arise.